Welcome to Sumner School Business Immigration Basics. In this video, we're talking about the difference between the EB-2 and EB-3 classifications, meaning what are those classifications, why is it important, how is it determined which category a particular case falls into, and when is that determination made. So the EB-2 and EB-3 classifications refer to the employment-based preference system. That is, they are classifications within the employment-based green card system. And it's important to know what classification your case falls into because it can impact how long you might have to wait for a green card to become available. We have a separate video on the visa bulletin and how to kind of decipher the visa bulletin and the factors that go into how long you might have to wait. So check out that video earlier on in our series if you're interested. So the EB-2 or EB-3 classification, like I said, may dictate whether you fall into the EB-2 or EB-3 classification, may dictate how long you have to wait for a green card to become available. So how is it determined which classification you would fall into? EB-2, the EB-2 classification is, at least when we're talking about green card filings based on the perm labor certification process, is for positions that require a master's degree or higher, or that require at least a bachelor's degree, a single source bachelor's degree, followed by 5 years of progressive experience. The EB-3 classification is for positions that require a minimum of a bachelor's degree or at least 2 years of experience. There's also a classification within the EB-3 category called other workers for positions that require less than 2 years of experience. You may have to wait longer for those particular classifications, or that can impact how long you might have to wait for a green card to become available. So again, going to the question of how is it determined, one factor is what is the actual requirement for the position. Another factor is what do you as the foreign national beneficiary actually have. So if the position requires a master's degree or a bachelor's degree and 5 years of experience, but you don't have that, then you're not going to have the case approved. In that case, we're going to have a conversation. You're probably going to fall into the EB-3 classification. So it does depend on both. Likewise, just because you have a master's degree, if the position that you're being sponsored for does not require a bachelor's degree or 5 years of experience, then you would fall into the EB-3 category. So you do have to look at both of those factors. When is this determination made? It's made really a couple of different times. It's really set by the way that the labor certification application is prepared, really set by the requirements of the position. So again, if the requirements of the position are such that at least a master's degree is required or bachelor's plus 5 years of progressive experience is required, then it's probably going to fall into the EB-2 category. If it requires less, for example, a bachelor's or 2 years of experience, it's going to fall into the EB-3 category. So it's really set by those requirements for the position and the way that those requirements are expressed on the labor certification application. However, it's not that actual classification, EB-2 versus EB-3, is actually made at the I-140 stage. So when we submit an I-140 petition, we mark a box indicating that we are filing for either the EB-2 classification or the EB-3 classification. And you can tell when you receive the I-140 approval notice, it will indicate on there which classification you have been approved for. So it's, like I said, really set by the requirements of the position, but we mark that box at the I-140 stage. In other words, if you look at a labor certification, let's say an approved labor certification, it's not going to say on the face of it EB-2 or EB-3. You have to look at the requirements to see what it would likely be classified as. Finally, it is important to note that it is possible to have an I-140 petition in both the EB-2 and EB-3 classifications. Sometimes a person will have a labor certification filed for employer A, and that labor certification in I-140 falls into the EB-3 category. Then perhaps that employee moves to a different employer, and that position is a bit more advanced and requires a master's degree or more experience, and it can fall into the EB-2 category. So just because you fall into one category at one time does not mean that you cannot move to a different category in the future. In addition, it is possible in some circumstances to have 2 I-140 petitions approved for the same employer. That's a little complex. It's beyond the scope of this video, but know that that is possible. There are situations, many times we've done this for clients over the years, where they have, for example, an I-140 EB-2 I-140 petition approved. And looking at the visa bulletin and the current situation, we've determined that it's advantageous for them to have a second I-140 petition approved in the EB-3 classification. That is sometimes called a downgrade petition. It's sometimes called it can be called an interfiling. But just know that it is possible to have an I-140 petition approved in 2 different classifications and could be a key part of your immigration strategy. I hope that you found this information helpful. If so, please share it with a friend or colleague. Make sure that you're subscribed. My name is Emily Sumner with Sumner Immigration Law. We serve clients throughout the United States and around the world with family-based and employment-based immigration matters. Until next time.